Good evening, everyone, and welcome to the Saskatchewan Law Review Lecture for 2022. My name is Martin Phillipson, and I'm the Dean of the College of Law, and I want to welcome you all to this evening's event. As we gather today, we acknowledge that we're on Treaty 6 territory and the homeland of the Métis. We pay our respects to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. And wherever you are coming to us from, either in Saskatchewan or across the country, please take a moment to think of the traditional owners of the land upon which you live. The Saskatchewan Law Review Lecture is part of the McKercher lecture series at the College of Law. And so on behalf of the college, I want to acknowledge and thank the firm of McKercher, LLP, for their continuing support of the College of Law lecture series. Their support allows the college to present a wide range of informative, educational, entertaining speakers for the law school and the surrounding community, and which speakers we believe broaden the discourse on issues of relevance to our nation, our communities, and to the legal profession. This evening, we're delighted to have the Honourable David Lametti join us as our guest speaker. The Honourable David Lametti was a full professor in the Faculty of Law at McGill University, specializing in property, intellectual property, as well as private and comparative law. He's also a member of McGill University's Quebec Research Centre of Private and Comparative Law, and a co-founder and member of the McGill Centre for Intellectual Property Policy. He served as the Associate Dean Academic of the Faculty of Law at McGill University from 2008 to 2011. Minister Lametti is multilingual and has taught at the university level in French, English, and Italian. In addition to his responsibilities as a professor, Minister Lametti was a member of McGill Senate and a governor of the Fondation du Barreau de Quebec. He was also a competitive soccer coach in 2 Montreal leagues for 6 years. Good for him. And a member, I hope the teams were competitive, and president of the governing board for his children's school. Minister Lametti holds a Bachelor of Arts in Economics and Political Science from the University of Toronto, Bachelor of Civil Law and a Bachelor of Laws from McGill University, a Master of Laws from Yale, and a Doctor of Philosophy and Law from Oxford University. Prior to starting his doctoral studies in law, he served as law clerk to Justice Peter Corey of the Supreme Court of Canada. Minister Lametti served as a parliamentary secretary from 2015 until 2019, when he was appointed Minister of Justice and Attorney General of Canada. Before I welcome him, I would also like to say that it's really nice to see David. David and I both taught intellectual property at one time and used to see each other at conferences, and it's a delight to see that one of us has at least been successful and become the Minister of Justice and Attorney General of Canada. The less said about me, the better, but I'm delighted to welcome to the College of Law and to deliver the Saskatchewan Law Review Lecture, the Honourable David Lametti. I'd like to welcome Michelle Willett and Michael McDonald from the McKercher Law Firm, and also, and you don't get to say this very often, we also have 3 judges of the Supreme Court of Belize with us this evening. Patricia Farnese, or the Honourable Madam Justice Patricia Farnese, is a faculty member here at the College of Law, but is spending a year as a Justice of the Supreme Court of Belize, and she's also joined by her colleagues Genevieve Chabot and Susan Lamb, so I'd like to welcome them as well. And now I will hand it over to the Honourable David Lametti. Thanks. Sorry, David.
Thank you. Hello, bonjour, Kwe. I'm pleased to send you greetings from my office here in Ottawa on the traditional territory of the Algonquin and Anishinaabe Nation. Thank you, Martin, for that invitation. I miss those old IP days, I have to admit. And I miss the soccer coaching days, although finally our men's team is following in the footsteps of our women's team. And you know, as an immigrant kid growing up in Canada in the 70s, we all thought it would be 5 to 10 years before Canada would be a competitive soccer country. It's taken a lot longer than that, but it looks like we're there, and so I'm pleased about that. It's an honor to deliver the Saskatchewan Law Review Lecture this year. I want to thank McKercher for the support that they give to the great law faculty at Saskatchewan, and I think that kind of support is critically important. So thank you. I was an academic for long enough to know how important this support is, and I welcome all the students and all the colleagues who are joining us, and in particular the members of the Judiciary of Belize, permanent and temporary. So thank you for that. Thank you for being here. I'm sorry I can't be here in person. As an old professor, and I mean that in all senses, so as an old professor, but also as being old and an old professor, there are a few places that I enjoy more than being in the lecture hall. And although we're here virtually, I'm thrilled very much to be here. Past lectures in this series have covered significant areas of the law, that speak to our aspirations as a democratic country founded on the pursuit of peace, order, and good government, with the themes of inclusion and diversity, access to justice, and human rights. So just as a small aside, I know that there's a large Ukrainian Canadian population in Saskatchewan, and I'm very sensitive to what is happening on those that assault on democracy and that assault on peace and democratic government and human rights justice that's happening in Ukraine right now, and I know that's all top of mind to all of us. But I'm going to come back to a domestic challenge and justice challenge, which I think is or ought to be top of mind to all of us. I know it is for you at the University of Saskatchewan, particularly with the Native Law Centre that's nearby. The topic I am discussing encompasses all of these themes. It also holds the potential to transform our country, and that is reconciliation with Indigenous peoples. My pitch to you tonight is that I believe, slowly but surely, the building blocks are being put in place to build a process to enable reconciliation to flourish. And with that, I think, I hope, I dream, a better Canada will emerge. So let's start by defining our terms. What does reconciliation mean? If we look at the final report of the Truth and Reconciliation Commission, we find the following, and I quote, "Reconciliation is about establishing and maintaining a mutually respectful relationship between Aboriginal and non-Aboriginal peoples in this country. In order for that to happen, there has to be an awareness of the past, an acknowledgement of the harm that has been inflicted, atonement for the causes, and action to change behavior." Here's a variation on that definition from Abel Bossum, who is the former Grand Chief of the Quebec Cree Nation, the James Bay Cree on the east side of James Bay. For me, reconciliation is about resetting the button. It's about looking at the past, acknowledging that we made mistakes in the past in all different sectors, and resetting the button and starting to work together. And finally, something from my friend Natan Obed, who is the president of the Inuit Tapiriit Kanatami, ITK, the Inuit National Indigenous Organization. Part of this new partnership and trying to figure out how to speak the same language and what we're all trying to achieve together. These definitions are a helpful shorthand for what is a complex and nuanced relationship. My definition includes everything you just heard, with one additional piece. Reconciliation is also about a process, both formal and informal. Reconciliation needs a vehicle by which the consequences of colonialism can be repaired and undone. That is because the reflexes that have defined the Crown and Crown Indigenous relationships are centuries old. The damage of colonial laws, policies, and attitudes remain with us today. Undoing them, rewiring them, will take a lot of time and a lot of work. Painstaking and patient work, but it has to be done. Let me come back to my influences first on this important issue. Look, I'm clearly not my predecessor. Jody Wilson-Raybould grew up with these issues being discussed at the kitchen table and has devoted her career to advancing the cause of reconciliation, particularly in British Columbia. My experience is different. I'm the son of immigrants. I grew up in Ontario. My real exposure to Indigenous rights did not happen until I was a clerk, Supreme Court of Canada. So my frame on all of this is through the law. I was fortunate in my timing. When I was clerking, the court was deliberating and ruling on major Indigenous cases, and that experience was fundamental for me. Sparrow was being decided and written up during my clerkship. It had been heard just before I got there. And I was able to see the Seaweed case argued and drafted. What I learned was that there were more than two ways to seeing the world. It was not through the common law or through the civil code. As a professor, this expanded approach was baked into my teaching. I was teaching property, And I remember using the Vanderpeet trilogy, and Delgamuukw shortly after each was decided, when they were still in the preliminary first judgment versions of them, with my students. And I decided it was critically important for my students to understand the multifaceted nature of Aboriginal title and Aboriginal rights. And those cases, I think, deepened my understanding as well. Canada is blessed with brilliant Indigenous legal scholars and advocates, people such as John Burroughs and Val Napoleon and Doug White. And I had access to them and their work. Their work reminds us that there are multiple lenses through which to see the law and the relationships which define Canada as a legally pluralistic state. And I was doing all this in an environment that was very, at McGill at the time, under the influence of Roderick MacDonald, that was very much influenced or directed towards legal pluralism. And so that's my frame. These experiences and the wisdom of others have led me to conclude that there are paths forward that will work. Now, of course, as Minister of Justice and Attorney General of Canada, I'm just one actor. In government, we have two ministers now who are devoted specifically to the file, Crown Indigenous Relations and Indigenous Services. We actually have a third minister doing Indigenous and who does Northern Affairs, which necessarily has a huge Indigenous component to it. We have a Prime Minister who maintains direct relations with Indigenous leadership. We have bilateral tables with each of the three major Indigenous national organizations and sub-organizations on a routine basis. We have other ministers whose work intersects very closely with Indigenous peoples throughout government. I'll talk in more detail momentarily about the many initiatives our government has taken, which has helped advance reconciliation. But I want to spend some time first on the process that I believe can form the backbone of reconciliation moving forward. The process is the one created by the United Nations Declaration on the Rights of Indigenous Peoples Act, or UNDA. UNDA was passed in Parliament last June. It requires the Government of Canada to work in partnership with Indigenous peoples to align federal laws, policies, and practices with the substance of the declaration. That partnership is defined by certain principles laid out clearly in the Act's preamble. It draws the preamble, that is, draws on the language of the UN Declaration itself, acknowledging its importance as a framework for reconciliation, for healing, and for peace. It recognizes inherent rights and acknowledges the importance of respecting treaties and agreements. And it speaks to reject of all doctrines based on racist ideas of superiority. Such as res nullius, for example. It explicitly rejects colonialism in favor of relationships based on the principles of justice, democracy, equality, non-discrimination, good government, and the respect for human rights. It also recognizes that Indigenous, provincial, territorial, and municipal governments have jurisdiction to take actions within their own areas of authority that can contribute to the implementation of the UN Declaration. All of this language reflects the input from many Indigenous nations and many Indigenous organizations. It sets the context for our work ahead. I want to emphasize the significance, I think, of the Declaration to the future of our country. It's transformational legislation. It represents a critical step forward, recognizing, promoting, protecting, and upholding the human rights of First Nations, Inuit, and Métis in Canada. And this, I think, is the promise and potential of reconciliation. In the UNDA, we find language that speaks to the core of what implementing the UN Declaration is intended to achieve, and why it's so critical to the reconciliation process. Finally, it underscores the importance of taking into account the diversity within and amongst Indigenous peoples, including the cultural, linguistic, and legal diversity of First Nations, Inuit, and Métis across the country. So I think there's a lot of promise in this document. I think it will go down as one of the great documents in transformational documents in Canadian history, and will change not just the substance, but the processes by which we do things. And to me, that's important. But there's a lot of work ahead. It begins with an action plan, something that the declaration itself demands, or the act itself demands, implementing the declaration under. This work is being done in consultation and cooperation with Indigenous peoples. It will outline the action plan, how we can achieve the UN's declarations and objectives. And that plan has to be ready by June 2023. So we've got an intense period coming up ahead of us. The ambitious timeline reflects the sense of urgency that First Nations, Inuit, and Métis conveyed to Parliament. They added that in the parliamentary process. We know what some pieces of the action plan will be. Must include measures to address injustices, combat prejudice, and eliminate all forms of violence and systemic discrimination, as well as promoting respect, mutual understanding, and good relations. It must also address monitoring, oversight, recourse, or remedy, and other accountability with respect to the implementation of the UN Declaration. And it will provide for review and amendment of the action plan itself. We expect our work over the coming months will lead to a plan that truly focuses on collaboration, one that includes accountability measures over and above what is already provided in the Act through annual reports and referral to the committee. Last December, my department launched a broad and inclusive engagement process with Indigenous peoples on the implementation of the UNDA. Along with this was a call for proposals to support Indigenous participation in the process. This includes support for Indigenous-led consultations. So it's not just the Minister of Justice leading consultations, it's Indigenous leadership groups leading their own consultations to identify their priorities for the action plan, for annual reporting on progress, and for other measures to ensure that federal laws are consistent with the UN Declaration. So Indigenous participation, Indigenous leadership, consultation are keys to this process. I believe that this vital work will help build stronger nation-to-nation relationships between the federal government, First Nation, Inuit, and Métis. At the same time, it will help support the path to self-determination for Indigenous peoples across Canada. And I think the work that we are now doing together will establish the processes by which the laws and policies of the federal government will be aligned with the declaration over time. This is the getting your fingernails dirty part of reconciliation. It's about working together collaboratively and about getting the processes right so that we can get the substance right. Together, we're rewiring a relationship so that it will be true to the promise made in our government's first throne speech in 2015, where we said, I quote, "We will undertake to renew nation to nation the relationship between Canada and Indigenous peoples, one based on recognition of rights, respect, cooperation, and partnership." It's taken time, but with the UNDA, we're at the beginning of a new and better way of working together. There are some people who think I'm naive, and maybe I'm a bit, or that the process we are embarking on is somehow insufficient to the task. But I'm not completely naive. I'm not blind to the challenges that we face. The work of reconciliation will continue long after I'm gone as minister. You can't undo 150 years of colonialism in the life of a single government. The intergenerational trauma caused by residential schools, by the 60s scoop, and by other injustices have led to profound impacts on Indigenous peoples and their communities. In my capacity as Attorney General, I see the range and complexity of litigation involving Indigenous peoples across Canada. Enforcement of treaties, questions of title, duty to consult, equitable treatment, just to name a few areas. You can look at all of this and think the problems are insurmountable. As an Attorney General, you can look at all of this and say, oh my God, what am I going to do? I can't solve any of this. But I disagree. And I focus on trying to leave the campsite better than the previous set of campers and doing what you can do. So I frame it in a more optimistic light. We are making progress. It starts with small things. I began my remarks with an acknowledgement of the Indigenous territory where I work here in Ottawa, and Martin did the same thing at the outset of this lecture. It's a simple acknowledgement, but it holds meaning and it holds weight. It's an expression of gratitude and respect, recognition of First Nations, Inuit, and Métis, and their special enduring relationships with the land. And it reminds non-Indigenous people of their relationship with the land they occupy and the need for accountability in their relationships with First Nations, Inuit, and Métis. Words are not enough, I know that, but gestures are important, and they must be followed by meaningful work, concrete action that guides us through the reconciliation process. I've spoken about the UNDA, and it's a collective work, and it's in progress. But there are other work that's ongoing, which is important to acknowledge. In 2019, we worked together with Indigenous partners to enact new laws to support the reclamation and revitalization of Indigenous laws, and to affirm and recognize Indigenous jurisdiction over child and family services. That latter piece, what was formerly Bill Sign C-92, jurisdiction over child and Indigenous jurisdiction over child and family services, inherent Indigenous jurisdiction, was recently upheld in principle in a 5-0 Quebec Court of Appeal ruling on that piece of legislation, saying that this was an aspect of the inherent Section 35 right to self-governance. And it's the first and most, I think, the strongest articulation of a right to self-governance that is part and parcel of Section 35 of the Constitution Act. And I think it's a landmark decision. I've taken the decision to appeal two parts of that the Quebec Court of Appeal did not agree with us on, but I think that part of that decision, and it hasn't yet been translated into English, but I would commend any of you to read it if you haven't yet. On Section 35 rights, there's a wonderful discussion of Section 35 rights, and we now have a robust affirmation from 5 unanimous judges of the Quebec Court of Appeal saying that the right to take care of one's kids is one aspect of a larger inherent right to self-determination of Indigenous peoples. And so it's a landmark. We've also passed legislation to improve Indigenous participation in environmental impact assessments and other regulatory processes. These recent laws and others refer to the UN Declaration, and they build on a number of Canadian laws and policies and programs that already reflect these elements. I've mentioned Section 35 and many provisions as well of the Canadian Charter of Rights and Freedoms, notably Section 15 on equality rights. And it includes the non-discrimination protections provided by the Canadian Human Rights Act, which is another very important piece of the puzzle. Section 35 of the Constitution is a good example of why reconciliation must go beyond words on paper, because the words are right there enshrined in the Act. It recognizes and affirms the rights of Indigenous peoples, including those set out in treaties with the Crown. And the fundamental purpose of Section 35, as affirmed in that Quebec Court of Appeal case, is reconciliation with First Nations, Inuit, and Métis. However, we have seen that constitutional provisions alone are not enough. We need to breathe life into them through action and commitment to the values that they embody. We need to focus on achieving reconciliation and the recognition of rights outside litigation. Litigation, after all, is by its very nature an adversarial process. So this speaks to the measures we've taken over the last 6 years to contribute to the process of reconciliation, guided by the UN Declaration, guided by Section 35. It also includes legislation related to First Nations, Inuit, and Métis children, to Canadian energy regulation, to First Nations land management, each of which explicitly acknowledge their intended contribution to achieving the objectives of the UN Declaration. We've developed and updated policies and guidance to assist federal officials' work wherever it involves Indigenous peoples. One significant example is the principles respecting the Government of Canada's relationship with Indigenous peoples. The document, released in 2018, aims to ensure that the rights and needs of Indigenous peoples are considered whenever new policies, initiatives, or laws are being introduced or considered. Another key document came from my predecessor, Jody Wilson-Raybould, in the Attorney General's Directive on Civil Litigation involving Indigenous peoples. And this document helps guide litigation positions being developed and advanced on behalf of the Government of Canada. Now, this is a work in progress, and we continue to work at making litigation decisions, but also raising consciousness raising consciousness within our litigators across Canada to abide by these principles and really try to push reconciliation forward. So these documents are both foundational, and they inform the development of the modern legal framework and clearly identify the core values that are guiding our day-to-day work. We can also point to measures like Jordan's Principle, which helps First Nations children living in Canada to access the products, services, and supports they need from whatever government these supports may come, and to the 2019 Recognition and Reconciliation of Rights policy for treaty negotiations in British Columbia. These are all elements that propel us forward and feed into the process of reconciliation. So using the UN Declaration as a foundation, we can see how it connects all the pieces of our broader work to pursue the very important and necessary goal, the just goal of reconciliation. This is especially true in the case of the justice system. We have to improve access to justice for Indigenous people. We have to address overrepresentation in the criminal justice system, and we have to tackle systemic discrimination and racism within that justice system. So desperately needed for Indigenous people, but I would mention it's also necessary for Black Canadians and other racialized Canadians who also face discrimination and inequality within our justice system. As part of this process, last December, I introduced legislation, Bill C-5, that proposes to eliminate roughly 20 minimum mandatory penalties that disproportionately affect Indigenous peoples, Black Canadians, and others. And as important as removing those minimum mandatory penalties, it would remove the restrictions on the availability of conditional sentence orders, which is critically important if we are going to make the recommendations of GLADU principles, or as well as race and cultural assessments, if we're to live up to their promise in terms of contextualized sentencing or finding other alternatives to incarceration where it is much more appropriate and will be much more effective to protect communities and to help address the needs of victims. These measures would enable the use of community-based sentences in inappropriate cases, which can help reduce recidivism without compromising public safety. And as I've said, address really the needs of the community and the needs of victims in a much more profound way. Finally, the amendments in this bill, along with the changes proposed to the Controlled Drugs and Substances Act, would bring a public health focus to simple drug possession. We're collaborating with Indigenous peoples to revitalize their traditional Indigenous legal systems. This responds to the Truth and Reconciliation Committee's call to action 50. At the same time, we continue to discuss and negotiate administration of justice agreements with a number of Indigenous communities across the country. We're also developing an Indigenous justice strategy, in consultation and cooperation with Indigenous partners and the provinces and territories. We recognize that the development of such an Indigenous justice strategy must be led by Indigenous people, their experience, their voices. And to this end, we've recently held a call for proposals, once again, to support Indigenous-led engagement that will inform the development of the strategy. This is a seminal step in addressing overrepresentation and systemic discrimination in the justice system. I'd want to see a world where we build community-based wraparound services to stop the revolving door of criminal justice, one where restorative justice is normal and uncontroversial, one where good policy confronts root causes and colonial impacts, and one where all of this happens in partnership with Indigenous peoples and service protectors on the ground applying Indigenous laws where possible, and using Indigenous normativity and traditions where possible to guide the process. I want to mention two other initiatives that I believe will be important to the goal of reconciliation moving forward. Both are in my mandate letter, and they're very important to me personally. And I believe both speak to our fundamental values as a country. Each has the potential to be transformational in their own way. As many of you will know, last year I asked former Justices Harry Laforme and Juanita Westmoreland Traore to examine how we should reform the process of reviewing criminal convictions. In January, their complete report was released. I'm in the process of reviewing the report and its recommendations, and my commitment to you is that I want to see the creation of an independent criminal case review commission. This is a fundamental access to justice issue, and one that I have been advocating for well before my time as minister, and frankly, which I advocated for since I became minister in order to get it into my mandate letter. The fact I needed to appoint 2 retired judges to look at the issue speaks to what has been missing from the legal community. A body focused on generating the ideas to modernize, improve, and reform our laws and institutions. We're bringing that body back to life. The Law Commission of Canada was defunded by the Harper Conservatives, and we've revived it. In December, we launched a selection process to find the president and 2 commissioners. And I look forward to seeing the Law Commission resume its critically important work, because it has an important role to play in the process of reconciliation. So these 2 institutions together, because many of the people who are wrongfully convicted, again, overrepresentation in the criminal justice system, are Indigenous. And so if we can facilitate their ability to have their sentences looked at, and the reasons for which the justice system wrongfully convicted them, we will be in a better place. And every single report that has happened after a major incidence of a wrongful conviction has had this as a recommendation, the creation of an independent body. And I cite Justice Corey's report in the case of Thomas Sofino. And Justice Corey was a mentor to me and has inspired me in so many ways. And this is part of my legacy to him. And the Law Commission of Canada is something that we need to think about, help us think about, by drawing together the best Canadian and international thinking in a way that's in a manner that's arm's length from government, in order to tackle issues such as reconciliation. And you'll remember that a previous Law Commission did a report on residential schools, which directly led to the apology by the Harper government, and has inspired our process of reconciliation in many ways since then. So the work of the Law Commission is critically important. Much of the work we're doing is to address long entrenched colonial laws and policies that have had an impact on First Nations, Inuit, and Métis. Last year, all Canadians, and indeed all the world, were shocked into that reality, that present reality, that past reality, with the identification of unmarked graves at several former Indian residential schools. Beginning with the discoveries at the Tecumseh First Nation in May, we all bore witness to perhaps the most horrific and shameful chapter of our collective history in this country. Since then, many sites have been identified across Canada, including in Saskatchewan at the Cowessess Muskowhegan First Nation and the Pasqua First Nations, as well as more recently at the Kiskus First Nation. And the search continues at many former sites. We know there are more sites. Indigenous peoples have long told us that these sites exist. For non-Indigenous peoples, these images and stories have been a shocking wake-up call to a tragic and racist colonial policy that has been pushed into the shadows for far too long. Of course, First Nations, Inuit, and Métis peoples have always known these truths. They are not accounts from the past. They live in the hearts and the memories of so many communities. The trauma is still there. They are reflected in the intergenerational trauma that continues to haunt survivors and their families. And they're found in the TRC's call to action, which seek to address the legacy of these schools, uncover the truth, and find a better path forward. This is the truth part. in truth and reconciliation. Coming out of these discoveries, which will still continue today, we've come to realize that Canada may need to create new legal tools to deal with these complex issues. To this end, our government has announced its intention to appoint a special independent interlocutor. This person will work with First Nations, Inuit, and Métis governments, representative organizations, communities, families, to provide independent advice for a new federal legal framework and to ensure the respectful and culturally appropriate treatment of these burial sites. A person who will build trust, a person who will open doors, and a person who will push discussion forward. We're currently collaborating with Indigenous partners to develop a draft mandate for this role, also informed by what we heard from Indigenous communities and experts. We're close to the end of that process, and hopefully the person will be named shortly. We cannot change what happened or undo the intergenerational harms that still haunt survivors and families, but we do have the opportunity to be a part of the transformation that helps dismantle the colonial and racist policies, practices, and systems that continue to exist today. Let me conclude with these thoughts. The work before us is daunting, but this is how it should feel. Reconciliation is the most deeply challenging and critical part of my mandate as Minister of Justice and Attorney General of Canada. When I was first appointed to this role in 2019, just over 3 years ago, I felt confident that I had a good knowledge of the issues and the history. I went in with an open heart, an open mind, and a willingness to learn and understand the complexities and expectations. I came to understand very quickly that I had a lot to learn. I was fortunate that there are Indigenous people of goodwill who have helped me. Former National Chief Perry Bellecourt, people like Chief Willie Littlechild, one of the architects of UNDRIP, whose wise counsel I've relied on as we've embarked on our collective voyage to implement the UN Declaration. Professor Sakich Henderson, who is the father of one of my colleagues, but someone that I've long held as an exemplar of what it means to be a great scholar and a great person. And Professor John Burroughs, who is, in my view, one of the most brilliant legal academics in Canada. And there are no other adjectives there except brilliant legal academic. These are just some of the people who've helped me on our shared path to reconciliation. The work challenges all of us in government and outside of government to think and act in new and at times uncomfortable ways. In our pluralistic country, with a deep, dark history of colonialism, we have a responsibility to rethink our approach in so many areas, including justice. For meaningful reconciliation to happen, we need to honor the truths we are told and to move forward into change. And as legal professionals, we have, I think, an additional responsibility to use our education, to use our smarts in order to help build the processes that will make true reconciliation possible. I've long said to my students teaching at McGill, and I'll say it to you, that because of by virtue of your education, you're sitting in these rooms, like it or not, you form part of an elite, and you need to use those skills that you now have to try to make the world better and to try to make Canada better. And if many of you apply these skills to reconciliation, as I hope you will, we'll get a step closer. There's a cultural shift that we must foster, one that lifts up the voices of Indigenous peoples who understand better than government can what is needed and how and when. So I return to where I began. Reconciliation's not a final destination. It's a process, one that's been underway for years and one that will continue for countless more. I opened with words from the Truth and Reconciliation Commission, and I'd like to close with them. The authors offer us this thought. Reconciliation must inspire Aboriginal and non-Aboriginal peoples to transform Canadian society so that our children and grandchildren can live together in dignity and peace and prosperity on this land we now share. This is our North Star. As long as we are heading in the same direction, toward a common objective of reconciliation, healing, and peace, with earnest intentions and good faith and with respect, partnership, and collaboration, we're achieving the promise of reconciliation and of the United Nations Declaration on the Rights of Indigenous Peoples Act. That's where we're going. That's where we have to go. And that's where we all have an obligation to get to. So with that, I thank you. Merci. Miigwech.
Thank you, Minister Lametti, for your thoughtful and very challenging presentation, and I really appreciate it. We've been working hard at the University of Saskatchewan College of Law in Osaka. As Henderson was director of the Native Law Centre for decades, and we've had a long-term commitment to Indigenous legal education here at the College of Law. And the reconciliation journey has only sort of emboldened us to do more, to move on that journey. And I think lawyers and law students have a great future in helping on the reconciliation journey. So thank you for your comments. I will tell the audience that Saskatchewan is the only province that's sensible and didn't change its clocks at the weekend. So the minister is now at 8:45. So I'm going to let him go soon without a question and answer period, so he can, even ministers get an hour or two off, I gather. So I'm told, even though they're non-unionized, I think they get a bit of time off. But I really do want to thank David, Minister Lametti, for spending some time with us this evening and his remarks. I will also point out that Canada's national soccer coach was born 6 miles from where I was born. So us lads in the northeast of England know how to run a football team, is what I'll say about that. But I'm very confident we will actually see Canada at the World Cup in Qatar later on this year. But I do want to thank the minister again for his speech, for his taking the time to spend with us, and also the message that he's delivering about everybody having a role, and lawyers in particular and law students having a role in moving the reconciliation agenda forward. And I really want to thank him for that. One last request I will ask is that, because it's the Law Review lecture, I would like the Law Review students, if they could, to switch on their cameras, and Katie will take a screenshot with me and the minister, just so we can have, usually, David, I should point out that the Law Review lecture, usually the speaker comes to town, we have a dinner with the Chief Justice of the Court of Appeal, and we get to introduce students. And sadly, COVID has taken that away from our students, but hopefully we'll be able to get back in person at some point. But I would like the students, if they want, to turn on their cameras. Katie asked me to do that. So Katie, let's see if people can switch on their cameras.
Thanks for your work. I did the McGill Law Journal when I was a student, and it was one of the most beneficial things I did to teach me how not to agree with the last article I read.
Yeah, this is my second stint as editor of the Law Review. Nobody's switching on the camera that I can see. Have I got the wrong view? Dawn, how am I doing?
No, we're good. I think all the students
are joined.
There we
go. It's me. I'm the techno moron.
I'm just going to give you guys a countdown so everyone's looking at the camera.
Okay.
1, 2, 3. We'll do one more. 1, 2, 3. Thanks, guys.
Thank you. And thank you again to the McKercher firm and to Minister Lametti. And hopefully, David, I'll see us in person sometime soon. But thanks again to everybody. Enjoy your evening, and thanks again. Bye-bye.
Thanks, everyone. Thanks, Martin.